Good morning, good afternoon, everyone. Very welcome to this session on how strong is the foundation, the challenges of implementing a modern statistical framework. This event is organized by the Inter-American Development Bank and Paris 21. My name is Paz Patiño. I'm a policy analyst at Paris 21, and I'm glad to join you as a moderator today. Before we start, just a reminder to our audience that they can send questions in the chat, and we will try to answer them at the end of this session. So please, while we go through the different interventions, you can already send your questions, and we will try to do that later in the session. For today, we have quite an interesting discussion lined up. We will be talking about the legal frameworks that regulate official statistics and what gaps still remain to make them efficient. So although this conversation is not new, for example, the modernization of the statistical legislation was already part of the 2015 Cape Town Global Action Plan for Sustainable Development Data. COVID-19 has highlighted the need again for modern legislations and actually modern statistical systems as we face an increased demand for data, the emergence of more data sources and producers than ever before, and in some cases, lower capacity of statistical systems due to the pandemic. So with this context, today, our expert panelists are joining us to discuss some of the pressing issues that remain around building and implementing a successful legal framework for statistics. We will be exploring what are the lessons learned around the statistical regulatory frameworks from the pandemic, what key pre-pandemic issues remain and need to be resolved going forward, and how the statistical legislation should be understood and implemented in the context of a widening data ecosystem. It is my pleasure to introduce our 5 speakers who are joining us today. First, we have Gabriel Gámez. He is the Interregional Advisor on Organization and Management of National Statistical Systems at the United Nations Statistics Division, UNSD. We also have Jimena Clark, who is the Executive Director of the Office of the Dean of the Faculty of Economics and Business of the University of Chile. She served as National Director of Chile's National Institute of Statistics in the past. We have Arturo Muente, who works as Modernization of the State Senior Specialist at the Inter-American Development Bank. Susie Fortier, who is currently Director of International Cooperation and Methodology Innovation Center of Statistics Canada. And finally, Nicholas Sherman, who is currently Assistant Deputy Director within the Central Policy Secretariat at the UK Office for National Statistics, ONS. Thank you everyone for your participation today, and a big thanks to our audience for joining us. So let's start with Gabriel. Gabriel, could you please tell us more about what we have learned from the pandemic? What do you think we have learned about the importance of statistical legislation, particularly to uphold resilient and agile national statistical systems going forward? Could you tell us a few takeaways of how to build better legislations going to the future?
Thank you, Paz, and I would like to thank the organizers, Paris 21 and the Inter-American Development Bank, for having invited me here to speak about what is actually my cup of tea or coffee every day, helping countries to develop their national statistical legislation so that it's supportive for the transformation, the needed transformation of national statistical system, but also the modernization of the system and the use of alternative data sources and innovative technologies. The first thing I would like to say, Path, is that yes, we, the statistical community, we have been strongly impacted by the COVID-19. I would say that first of all, it was difficult for us to produce our regular statistics because it was not possible to conduct, as we have done it in the past, our business surveys, our household surveys, no face-to-face interviews. And of course, this was a challenge. I would put that in the category resilience. Resilience is the capacity of a material to come back to its initial position after a shock. Right? So this was a little bit problematic, but this we have to work on. It's a resilience. The second one is the emerging demands, and this sometimes we forget a little bit. The demand changed. Our policymakers needed quickly data, statistics about the impact of the COVID-19 on the population, health, economy, but also, to already think a little bit further about the data that they would need for the recovery policy. So things that are going to come. And this is to be agile. And I would make a difference because sometimes we put agile and resilient together. Agile for me would be the capacity of a material to keep a deformation in order that for future impact or future collision, the impact is manageable. So there are two different things, but we have to keep them in mind. So how the legal framework can be supportive of resilience and agile national statistical system. One thing we have to keep in mind, and I know that many people around me are also saying, why all about the law? Why are we speaking so much about the law? The law is not only about obligations. The law is much about the rights. So what we are allowed to do, and maybe even what we should do. The law is not only about the producers. The law is about the right of the users, that they are core for official statistics. The data providers, these ones that give us data, third-party data, the National Statistical Office, but also the respondents to our surveys. We have learned that the countries that actually have been more agile, more flexible to adapt are probably those ones that had a statistical law that is rather short, that is dealing with the main principle, and that keep all kind of details of implementation and modalities, or in what we call bylaws, or even sometimes, and this is something that is rather positive, in a kind of like bilateral or multilateral arrangements that you can have, like memorandum of understandings with data provider. The law, for example, should avoid the list of the producers of official statistics. The law should avoid the list even of statistics that are produced by the system. I think we can imagine when we have such a new demand, emerging demand, and you cannot find the name of this new statistics or the new data set in the law, you first need to modify the law in order to be able to do it. The law is also, I mean, not when I say about, for example, the list of statistics, a good solution there is to have a statistical program for the entire national statistical system and deal with these things there. The law is, of course, not only about the National Statistical Office. The law should be about the national statistical system, how it is governed, how it is coordinated. But I would go even a step further. The law should be also about how the national statistical system, and in particular, the chief statistician, is interacting with the entire national data community. The law, of course, is not about the structure of the NSO and the number of deputies. This is something we can see quite often. And there again, when the statistical office or the national statistical system has quickly to adapt, the fact that it's foreseen that your office is structured in such a way in the legislation means in theory that you would have to go to the parliament to change the structure of your office. And this, of course, you don't want. So one thing that is important, I'll come back later on that, is that the chief statistician or the head of the National Statistical Office should have some managerial autonomy. And sometimes this also is something that they don't have because they are bounded by the administrative regulation on how the administration, the government is structured. One thing that is also important, I believe, is before, and that's for the countries that have decided now to go for new legislation, first ask yourself what kind of system do you want? And how do you want to interact with the data community? And then start to develop your statistical legislation. And please involve in these consultations and discussion all stakeholders, the users, the data providers, the respondents, and so on. One thing that is fundamental, and we have noticed, is trust. Trust in statistics is central. The law is mainly there to secure or to support this trust. Why trust is important? Because for most of the users, the operations, the statistical operations are not replicable. You can't do it again. And when you can't do it again, the only thing that is left is trust. And that's why the statistical legislation should be much about the principles of official statistics: accountable, transparent, universal, relevant, independent, professional, and ethical. When I say universal, it means the statistics is produced for everybody. and not just a small group of users. This is one point that is important. Now, if I come to a few provisions that we have seen during the crisis were very useful to countries. One is the provisions about the chief statistician. The chief statistician is the figure of the national statistical system, and even to some extent of the national data community. The chief statistician is not just a technician, right? The chief statistician must be a communicator. The chief statistician should be hired through an open selection. The trust starts there. The chief statistician should be hired with a fixed mandate. We have seen, ladies and gentlemen, dear participants, we have seen during this crisis a high number of chief statisticians being sacked. Where is the trust when they are sacked? Some people pretend that the data could not be. It must be something wrong. And you sack the chief statistician. This does not work. You lose the trust in the data, not only the data from the statistical office, but the data from the entire data community, right? The person who is leading that is suddenly sacked because despite all these modern technologies, some people pretend knowing better what it should be and how it should look. One point that is also important there is that, as I mentioned before, that the chief statistician has enough managerial autonomy to be able to adapt quickly the statistical office, but eventually also the national statistical system to respond to the demand. There is, of course, and then this is something that is quite obvious in the generic statistical legislation, and I'm finishing 3 minutes. Is that okay with this question? I mean, the first one is the access to third-party data. It should be explicitly allowed to do it. The obligation from providers of administrative data or administrative data holders to provide the information to the statistical office. And one that is, I would say, one of the most important one, and this is a little bit my conclusion, is confidentiality. We thought, I remember like 10, 15 years ago, that confidentiality was a little bit outdated because the people giving us the data, basically they give this information already to the web, to all these social platforms and all that. And then of course, it's probably not very important. But we have seen that for the access to third-party data, our partners, our data holders, they want us to be very strict on confidentiality. There is no exception there because they put their reputation also at risk. So they want that we have this provision in the legislation. It's a meeting about the law, but of course that all technical measures are taken. There is no trade-off, and maybe I will provoke here some people. There is no trade-off between confidentiality versus the right of information. There is a trade-off between privacy and data protection on one side, and especially privacy, and information. And this is a point that is important. Legislation that are regulating access to data, privacy, data protection is first of all not the statistical law. The statistical law protects confidentiality. And I've been in many countries where actually these regulation on transparency, data exchange, open data, and so on, were discussed at the parliament, and the chief statistician was not even aware of that, right? The chief statistician must be consulted and even better, involved in the development of all kind of legislation that apply to the entire data community, right? But allows the use of data that are collected, reuse for statistical and research purposes. This is, of course, something that is fundamental. Of course, and I want to maybe conclude with that. Again, once we have a statistical legislation, we have a framework, we have the grounds, we have something we can build our national statistical system and data community on that, but that's not everything. We have to work, we have to implement it, we have to enforce it, and we know how important dialogue, partnership, and communication is. Thank you very much.
Thank you very much, Gabriel. I think you've brought up a lot of important issues, and especially how do we keep the statistics law flexible enough in these times of changing environments. Let me bring maybe something that you mentioned about keeping the statistics law quite general, and then actually using bylaws, all the regulatory frameworks, and even memorandums of understanding to make it more operational. Let me ask Jimena maybe to in your experience as head of the National Statistical Office in Chile, what were some examples in which you noticed a conflict between these different legal frameworks dealing with data governance, and how are they complicating the work of the statistical system in the present?
Well, first of all, also thank you for inviting me to this session. And I have to say that when it comes to think about data governance, first thing, to have an updated statistical legislation is very, very important. However, there are other legislation that relate to data and that can sometimes generate tensions with the statistical activity. For instance, you might have some sectoral legislation like the tax one that establish their own confidentiality safeguard, such as the tax secrecy, and that affects the access to their administrative data for all producers of official statistics, like an NSO. But then in more general terms, there are at least two laws, very important, that interact with the statistical one, which are the law on access to public information, the one we call the transparency law, and the personal data protection law. So from my experience as a head of the Chilean NSO some years ago, I have some examples on that. And I have to start saying that in Chile, we still have a pretty old statistical legislation from 1970. So it is not as explicit as we would like on all of the provisions that Gabriel just mentioned are important. And on the other hand, we have a transparency law, which is from the year 2008, and which does not incorporate the statistical confidentiality as one of the reasons based in which access to data could be denied. So some years ago, we experienced a very big tension between the transparency law and the statistical one, because the agency in charge of implementing the transparency law interpreted that we had to disclose a particular information from a survey in a format that was not anonymized. And even when we were not required to provide the ID, for instance, we were required to provide a set of variables with which it would be easy to determine the informant. So basically, we were asked to provide determinable data, and that would violate the statistical secret, affecting trust people had on the NSO. And we just heard how important is trust for the statistical community. So it was a long story, but we ended up disputing this case at the highest level of our judicial system, that is at the Constitutional Court, and we won. But the problem was that even when the court ruled in favor of us, the NSO, and so we did not provide that data with such a level of disaggregation required, the reason they based their decision were not the statistical reason regarding confidentiality. So they consider it rather an administrative reason, that is a reason based on the form of the process rather than on the essence of the discussion, rather on the importance of safeguarding confidentiality. And then our judicial system is such that this sentence from the court applied only for our particular case. And so eventually we could face another similar case, and that would affect the credibility of the institution, no matter what the result is. And so I have to say that it is not popular to have a dispute with the transparency agency. And that brings us to the point that it is very important to ensure that both laws are coherent, and to make sure that the transparency agency personnel also understand how crucial it is to respect and to guarantee the statistical confidentiality for producers of official statistics. As a minimum, I would say as a minimum request, we would need, or we would like to have that in both laws, it is explicitly stated that when it comes to safeguarding confidentiality, data can be denied on those requesting it. And then, of course, we need to work together with the other agencies like the transparency one, as I just said. So this is my first example. I know other countries, at least in Latin America, face some similar experience. And then with regard to the second legislation, the personal data protection one, the tensions occur because when producers of official statistics need to have access to administrative data, but that is restricted as a result of the fact that the law on personal data does not specify the possibility of this access without asking for the permission of every person. And even when this, even if this access is allowed in your statistical law, sometimes administrative data providers do not allow to this access based on the lack of the permission from every person. And so this is a big tension also. And we cannot ask, of course, the authorization from every person in order to use this data for statistical purposes. So we, again, in Chile had special tensions with the Internal Revenue Service. And I have an example which it's like a funny one, but it is not funny at all, which is that when I started being the head of the NSO, there was also a new director of the Chilean Internal Revenue Service. And this person, who had worked for a long time at the IRS, had a proposal in which he proved that the administrative data could be combined in a safe way, that it would, without revealing the ID, and so we could have access to use nominated data, but without risking the confidentiality. So I went to speak with him to have access to their nominated data because we wanted to use them for our economic indicators. And I had his own study as a fundamental evidence that we could share the information. But at the end, he, in his new position, sent me to speak with the legal department. And so that was the end of the story. You see, when he had to decide on that, given that the access to the data was not explicit on the law, and even if he had his own research saying that we could have access in a safe way, at the end, the access was denied. And so that brings us again to the importance of having a legal framework that is explicitly enough on such access, and so that it reduces those type of tensions. I just spoke about tax data, but when it comes to the pandemic, it is health data. And it is not funny at all not to have access to data that could save life. So that is the importance. This is one of the importance of having a robust legal framework, combining all of these legislations so that we can have the most efficient production and useful of official statistics, basically.
Thank you, Jimena. Those were very valuable examples. I'm sure a lot of the people today in the audience can relate to the challenges on how to make work of the different regulatory frameworks and actually make them coherent to the use of statistics. Now, let me maybe go back to what Gabriel had said, that these regulatory frameworks are not only for producers, actually, they are for a much wider set of data ecosystem actors. And let me bring in Arturo. Arturo, how do you think the non-governmental members of the data community perceive these official statisticians when it comes to data governance?
Thank you. So, great. So thank you for the invitation. I'll start by saying, and this is fairly obvious, but I think it's still worth bearing in mind that not all countries are the same, and the institutional arrangements in each country is a little different. So I'm going to be talking probably more from the experience in Latin America and the Caribbean, where I've been spending the last 5 years exclusively working on data communities. I'm going to be a little provocative and say that the answer to the question is kind of embedded in the question itself, because by referring to the data community in third person, I think that's part of the answer. It's this distancing that is perceived between national statistical offices and the data community. But I'm going to try to build this case from 3 different sort of points that I think also reinforce each other. The first one is you know, if we see the last 10 to 15 years, probably even 20 years, we've been trying to deal with different problems that have been appearing around data issues in an isolated manner. So, access to information, a problem that both Gabriel and Jimena have mentioned. Open data, which builds on top of access to information. Data protection, something that has appeared probably in the last 5-10 years as an extension of privacy applied in the digital space. You also have data sharing, interoperability. You have cyber, there's a big chunk of it that deals with data. You have international legislation and data exchanges, something that the EU, for example, has been putting a lot of attention to. And all these issues have been sort of dealt with trying to cross vertical silos, which are there. They still exist, and you've been trying, or we've been trying to cross those vertical silos. My hypothesis is that while trying to break those vertical silos, we've been creating horizontal silos. And these different groups have not been talking to each other. And what Gabriel and Jimena have been saying is actually the result of that. Lack of coordination between the agendas, openness and protection being seen as enemies, quote unquote. And I've heard that in some other meeting I've had. And that's something that we see right now. So the landscape is, fragmented. There's no integrated approach. Again, albeit some countries that are starting to think about national data strategies. We have 2 countries here that have done that, and I would be really happy to listen to their experience there. But in general, I'd say we have this sort of siloed landscape. Now that's Act 1, so to say. In Act 2, what we see is that there are, maybe because of this, but also because of how the industry and the data sort of landscape has been evolving itself, the government has started to having to deal with a lot of issues, and they have to strike some balance there that is not very easy. So there's balance, and I think a couple of them have been already mentioned: balance between openness and protection, balance between promoting innovation and protecting fundamental rights, balance between inclusion and efficiency, balance between the opportunities and the risks, balance between ex ante and ex post regulation, balance between local and global kind of approaches. And all these only makes this sort of landscape a little more convoluted and dynamic. And there I want to build on the need for a more sort of agile environment, and how do legislations, which, by the way, each of those horizontal silos I mentioned has probably a legislation in itself that has, as Jimena mentioned, and I think Gabriel too, have not been coordinated necessarily, not only with NSOs, but with the other actors in this sort of ecosystem. How do we start thinking about striking that balance between all these different sort of objectives, each of them taking independently, of course, worth pursuing, but when taken as a whole, requires that kind of balance. And the third one I wanted to make, and I'm going to be very short because I really want to hear my colleagues here, but is this sort of crisis of trust in government that we're going through, and I would say, I mean, regionally and globally. And I think Gabriel mentioned it when talking about how some head of NSOs have been sacked, questioning the quality of the data. I would make it more general in terms of trust in government, trust in institutions, and somehow linked to trust in the data that these institutions are providing. So what should NSO's role be in this convoluted environment where we need some kind of a beacon in terms of trustworthiness? And that may also add an additional balance here, which is the balance in the relationship between NSOs and the executive and the administrative data and the whole data community, in terms of being at arm's length, but also being collaborative and also being cooperative and also building on top of each other to build and to construct a more sort of inclusive and integrated data landscape. So going back to the original question and my first assessment, I would say that having NSOs become part of that data community, and first and foremost, seeing themselves as part of those communities, I think is the first step in a not easy journey. Thank you.
Thank you very much, Arturo. This is quite an interesting, I think, key issue that we are facing in the statistical system. How do we make a coherent and inclusive data community that we can grow? And I think you were right on top you hit the nail on its head by saying that, well, at the moment it's a bit of a separate situation with clusters working separately, but the ecosystem is starting to really evolve and grow. So let me ask Susie, you know, as the data ecosystem keeps evolving and broadening, what has been the experience of Statistics Canada trying to align this evolution and existing work and legislation regulatory frameworks that you have set already?
Thank you. So thank you for the session, and thank you for this question in particular. So, but before I go to the question itself, let me give you a little bit of background on our legal framework. So as mentioned by others, like the official statistical activities are really, the basic of that is really the legal framework. In Canada, our work is governed under the Statistical Act. It's something that has passed in 1918, so more than a century ago, which created the first Office of Statistics. It was the Dominion Bureau of Statistics, who changed name in 1971 for Statistics Canada. And our act was most notably amended a few years ago with final approval at the end of 2017 to better define the independence of Statistics Canada and to include some of the elements that Gabrielle was mentioning before about the role, the mandate, and how the chief statistician was named and so on. So the Stat Act gives us the authority to collect, compile, analyze, abstract, and publish information on the economic, social, and general condition of the country and the citizen. There's similar phrasing for all of the legal framework that we see in between countries. But again, a little bit like previous panelists that I've mentioned, it's not only what can be done, but it is a balancing and what can be done, what should be done, kind of the balance between the right and the responsibility. So it does give extensive power to collect the information, and like sometimes we refer to it as the superhero proverb or the Peter Parker principle, right? With great power comes great responsibilities. So to balance these extensive power, and I really like the previous discussion of everything that we need to balance in the ecosystem right now. So to balance these powers, we also have the legal requirement to protect the confidentiality, just to name one of the balancing acts that we need to consider. So a broader view of this is not only related to how we publish and disseminate the information, but also how and if we gather the information itself, with privacy being at the forefront of our mind. And it has always been of the utmost importance at StatCan in all of the actors and NSOs and in this panel for sure, I'm sure, but also in the broader ecosystem. But so, even before the pandemic, I think we all knew that society was on a rapidly evolving path, and that the measurement challenge and the opportunity related to that were not only what they were just a few years ago. So with the pandemic and the speed at which everything, both from the information need and the opportunity from technology and the potential of information, everything is faster, bigger, there's even more opportunities. So what it is right now, it's not so much that it's not the same as what it was a few years ago, but I could even say of what it was a few months ago. That said, even if things change rapidly, the example I want to mention is a little bit older, but not that old. I want to bring you back to 2018. So like many others, we were thinking and exploring new data source and innovation collection method. Our example is related to exploring the use of credit and banking data from third party, from banks directly, not from the direct population. And these plans raised concern, and there was an investigation from the Office of the Privacy Commissioner in Canada into the plans that Statistics Canada had to acquire these data sources. We've talked about this experience in other venues before. The Privacy Commission Office provided us with their assessment on the design of those pilot projects, financial transaction project, and credit information project. And those assignments clearly stated that we acted within the legal frameworks, like there was nothing illegal, but still that we could do better, as if that it was still not enough. They gave us recommendation from improving these programs, and which enable us to have a more rigorous process to protect the privacy of Canadians. So what we did is that we worked with various experts around the world, as well as the Privacy Commissioner Office itself, to develop a method rooted in the principle of necessity and proportionality. So we built a necessity and proportionality framework, which is kind of a transparent approach to maximize the production of information and privacy protection when we're designing a data gathering approach. So it's kind of our answer to that balancing challenge that was mentioned before. So this is anchored on a solid scientific approach, and it was developed in consultation with a large number of experts that I mentioned before. So on the statistical side, privacy and law and ethics. The framework starts with the necessity part, describing why the data are needed. It touches on high-level needs, which are also relevant in the crisis health situation that we had in the pandemic situation. But it goes deeper than just the high-level need. It goes on the potential impact of the statistical use of these data for the Canadian. And then the necessity is translated into working assumption in terms of the level of quality, disaggregation, granularity of the estimate, and so on. And the proportionality part is the equilibrium that we achieve when the data strategy fulfills the need while protecting the privacy. In its implementation, there are 4 considerations: assessing the data sensitivity, considering the ethical issue, revisiting the design element, and the incremental process of the scientific approach. So it goes in an incremental process. This can lead to revisiting the working assumption. Now, in a traditional framework, all of this is already there, but there's more flexibility in the framework as we have operationalized it right now. So how does it work in practice? You can see it as a documentation process, but it's not done to be seen as an administrative burden. It's really more a thought-provoking process. It's demonstrating the critical thinking that goes behind every project. It's an extra step that goes over the legal framework, and it's not because you can, but it's not because you can that you should. But on the flip side, if you can and you don't, there are insights, opportunity loss for an informed society that needs to be considered when you don't want to leave no one behind. So let me wrap up. I'm getting out of time. So our strong foundation enough? Well, they're absolutely a necessary component, but today we need to address issues related to sensitivity, privacy, and ethics that comes with the new reality of the source and technology that we're using. This relates both to the framework, but also more fundamentally to the principle and the core values, the relevance. We are no longer only providing data, but also providing data services, professional independence that was mentioned before. We don't want to be isolated. It really needs to be done in a collaborative effort in the data ecosystem. Privacy, confidentiality that I discussed a little bit earlier with more emphasis on the data ethics, the use of sound method and scientific integrity. This is a large component of what we bring to the table with our data know-how, and of course, full transparency. So to some extent, like others mentioned, there should be coherence between the mandate, the legal framework, the core values, and all of this interplays together. And with that, I'll leave it. We could see that those core values could maybe be guideposts for future modification of the legal structure in the future, so that we can really have a better and more integrated role in the digital society. So thank you.
Thank you, Susie. Thank you for sharing the experience at Statistics Canada. Quite an interesting, I think, view on how to reach the data communities, how to explain why and how you're collecting, and also what's the impact. I am really hoping that this will be, or I know this will be some useful examples for our audience. Now, reaching our last panelist, we have been talking about the elements that makes for a strong data regulatory framework, and what about statistics law makes systems resilient. But Nicola, ONS has what we might consider strong statistical legislation, or the UK has one that is a strong statistical legislation, ONS as the data governance head. And what comes after you reach this point in order to ensure the legislation is successfully implemented? What has been your experience in the UK?
Thank you. Thank you to the panelists who've come before me and the organisers of this panel asking me to come along. I think legislation is a great start. Obviously, you need to build on those foundations. But the thing about legislation and law is it's constantly alive and it's constantly being reinterpreted, often by people outside of the statistical system. And that puts, if we rely on that as our foundations, that puts these foundations under quite a considerable amount of stress, and we have to constantly, as the NSI, be the custodians of them and work hard to maintain them. And this will apply across the whole of the stats system. This is, you know, good legislation still isn't a magic bullet. A law helps, but if not implemented properly, it won't make an NSI independent, it won't make it inclusive, it won't make it trusted. All of that stuff comes from building on the foundation and doing other things, working with your stakeholders, working across the system and building a reputation for trust, honesty, openness, transparency, all the things that and Susie mentioned it before, our core values. And it is really taking the law and using it to deliver our core values. We face challenges across all these fronts, and our job in NSIs is to instigate the culture change, to change people's perceptions, make them happy to share data with us, make them understand the value of statistical confidentiality, understand why it's important that your statistics are produced in an independent way that is transparent and people will understand how they're produced. The law won't do that. You have to keep working and you have to take the law and you have to keep building on it and using it as your ally. And to give you an example of where a law doesn't work, if it's not agile enough, if it's not relevant enough, if it's not timely enough. We had a previous legislative regime in our first statistics law back in 2008, which essentially gave us data acquisition powers, but in some cases it would take us up to 18 months to get that data in, which meant by the time we actually produced any statistics from it, the issue which had generated the need for that data had moved on, and the world moves on very quickly. We faced a huge cultural caution, so we needed to kind of change that law and get greater data sharing powers. And in the UK, we went back and we entered into an open policy making process. We took all our stakeholders with us. There's some very influential people at the top of government who were quite happy to back us on this. We had a big ambitious ask and we got the law changed, and we got it changed into a way that would give us greater and wider data sharing powers, which would allow us to effectively do more with data. Even though we knew that law was coming, we didn't assume as soon as we got those powers it would be all okay. We knew we had to start thinking about how we use those powers and how we implemented them, how we made sure we were the ones that were leading the discussion on how the interpretation of that law was going ahead, how it interacted with other laws such as our data protection law and our privacy law. And we had to work hard to do that. That wasn't something that came just automatically from a new law. And this meant working with some really key stakeholders. Like I say, the Privacy Commissioner is absolutely key. Your head of your NSO should be meeting with the Privacy Commissioner on a regular basis. We needed to be really confident. Like I say, we needed to be the ones who are leading the debate on how the legislation should be interpreted. And we need to be transparent. This legislation gave us great powers. And as Susie said again, great powers come great responsibilities. We need to be publishing our policies that supported our actions under this law. We need to be transparent how we were going to do it. And we needed to make kind of this all out so nobody was surprised by anything we were doing. And this really came home and bore fruit during the COVID pandemic recently, where the legislation didn't open any doors for us to get data in. It didn't, on its own, it wasn't doing that. What it did do though, when we entered into discussions with people who wanted to get data to us, we were able very quickly, by using the law and by floating the law and saying, look, we have these powers, that was then able to facilitate very quick transfers of data, and a lot of the questions had already been answered beforehand. So again, the law was useful, but it wasn't the thing that actually change the culture. It was all the work, all the trust we built up before that. There's still an awful lot to do and lots of legislative questions that are not answered by any stats offices across the world. There's a question of paying for data versus getting a law to effectively open up all your data sources. It's great being able to get any data you want, but unfortunately, most of the data when it's out there is not in a format you want. So you will have to pay someone to put it in. So maybe we need to think about better metadata standards across actual data systems across the whole country. Working with government, making sure independence never becomes isolation. You are there as part of government, but you're independent from government, and that's really important. Better international exchange of data. As we become a more globalized society, we need to make sure we can share data safely across different stats offices. And then there's ethical and data protection issues that never stand still. These are ones that change as new laws and new things come into power. And we need to be, again, aware and ready to respond to those changes. In the UK, we have an ethics committee that constantly looks at the ethical use of data for the National Statistician. And that really puts us ahead of the game and absolutely valuable when we're entering into discussions with people. But there's also security standards, there's safe environments within your organisations. All of these things are going to be absolutely crucial to building trust, to building a wider culture of which the law supports and gets you so far. And finally, just other things I could mention: inclusivity, that helps you break down barriers by making sure you're representing all the community that you're out there monitoring. Quality and communication is absolutely vital, and the law can't do communication for you. The law cannot put the statistics in the hands of people. You have to go out there, you have to make sure you have a communication strategy. So all this great stuff the law's allowed you to do, you then go out there and you make sure you tell the people, because our job's not done until people understand and use our statistics. And I think that's where I'd like to leave it.
Thank you very much, Nikki. Thank you for sharing what is happening in the UK and what an important role Honest has taken in the shaping of the statistics law and how data is being shared. So now we will go forward to some questions from the audience that we have here, and I will ask all our speakers to please keep, because we're running low on time, so we can keep these answers to 1 minute, and we will make a round, all of us, with some of the questions. So let me start maybe with Jimena. Jimena, we have a question here on how do you combine or how do you balance confidentiality for third-party data and transparency? So a bit of the balance between what is urgently needed in terms of data and confidentiality, for example, in the use of health data during the pandemic. What would be your advice?
Well, the first thing is that differently as people tend to think, there is not an opposition regarding confidentiality and transparency. The thing is, when speaking about statistic, transparency is basically to let people know what I believe Nicola was just saying, and why do you need this information? How are you going to use it? What are the methods you are going to use it? And how are you going to respect the privacy, the confidentiality, this balance of right and duties, basically. Now, when it comes to things as sensible as health, you have many ways to create alliance with your administrative data providers. So the first thing we have realized is that basically most of the other public institutions do not know how, are not as expert in collecting data, analyzing it, disclosing it, or letting people know, or using it, in fact. And so this is a strong capacity that the statistical community has. And so you should be able to construct alliance. So you teach them how to better collect and use their data. And at the same time, you get access also to this data for your own purposes. So there is no opposition there. There is no conflict there either on confidentiality and transparency and all of these other characteristic.
Thank you, Jimena. We also had a question on the generic law of statistics. So maybe I'll call on Gabriel for your advice on this one. What is the plan on, are there any regular reviews of the generic law plan and how to keep them up to date? And what should be covered specifically in the law and what in the regulations that come with it?
Thank you very much. Yes, I saw also in the chat a few questions. There are two actually. I can actually answer the first one that you just addressed, and at the same time the second one. What is important and we really need to keep in the legislation is to make clear that we are here to serve our users. Official statistics, maybe we have been a little bit enthusiastic in 1991 when we developed the fundamental principles of official statistics, but it was to empower citizens. And we have to remember that this is our role. The second thing in the law, we have actually to protect the respondents. It's very important. But now, I mean, not only the respondents, but also the data providers. Confidentiality is one that is fundamental, of course. The other one with the users is the relevance. We have to be relevant. We have to be confidential. And in between, there is the production process, and there we have to be professionally independent, right? These elements, I think, are really fundamental. They are in the gloss that is actually going in the process to be gradually revised. And we have a meeting with UN-ECE is organizing a workshop about the gloss and what could be the elements to be revised, taking place in November online. So I invite everybody to participate. It's easy now that it's online, and maybe also to share their opinion. But this is something that is very important. There are a few elements we have to polish. We have seen that sometimes the role of the central bank was not very clear. We have seen that sometimes the access to administrative data, other data where they say without costs, who is bearing the cost when there is a technical cost. We claim now the thing of timeliness. I mean, of course, we can get access, but if it's in 2 years after the end of the reference period, it doesn't make a lot of sense. I wanted also to mention that the gloss that was developed in UNEC, and Jimena is well placed to know that, was developed also, I mean, translated for Latin America into, I mean, not only into Spanish, but into the Latin American context, but also for the Arab region. One thing I wanted to say, the law. We have a little bit the tendency at the moment, and we have to be careful, to continue to put our users in the center. We are there and we have to be demand-oriented. And there is a risk with big data that we gradually become supply-oriented. Give me all what you have and I will see what I can do. But in some cases, it does not address the request from our users. So we have to keep in mind, and this has been always our job, to try to find the data in order that I can compile statistics and indicators to address a demand. And I believe this must remain in our statistical legislation. Otherwise, official statistics is no more sustainable. And sustainability is also important for statistics. And I wanted to say, to conclude, I agree with all the panelists. I mean, I got even the impression that we had long sessions of preparations. I mean, it's just beautiful. So thank you very much, everybody. Thank you.
Thank you, Gabriel. Thank you for those words and very useful advice. Let me go to another question. This one is for Nicola. You mentioned trust a few times, and could you give maybe an idea of what ONS is doing to grow this trust in the population? So what kind of actions are you taking forward?
Yes, of course. So one thing we do is we monitor how much we're trusted as an organisation. And so we run a survey every 2 years, a public confidence and official statistics survey that has produced some fantastic numbers and shows that actually as statisticians, we are trusted far more than the media, politicians. Now that won't be maybe a surprise too much, but we are literally at sort of 78, 80% levels of trust from the public in our statistics. What we also do is in the UK, we have an Office of Statistical Regulation. That was created in the same legislation, and that basically calls out when there is misuse of statistics, and it's done very publicly. It's done in conjunction with our Parliament, and politicians who misuse statistics or statistics that are produced that are of not sufficient quality are highlighted, and that is made very public and done in a way that basically says we are serious about maintaining quality. We're serious about maintaining trust, not just in the production of statistics, but in the use of statistics. And we have called out the government on a number of occasions during a whole host of debates, whether that be on health statistics, knife crime, or even figures used in the debate whether the UK left the EU or not.
Thank you for those examples. Very interesting examples. I have another one here for Susie. Susie, as the supply of data continues to grow, how is it, how difficult or how complex is it to determine now who should be the custodian of that data between the different government agencies? What's your take on this?
My take on this is that it might not be a question that can be answered in 3 minutes. No, I agree that it is a complex challenge. It is a complex challenge depending on the organization and the geopolitical situation. In Canada, we have province and we have some of the data. For example, health data is under provincial jurisdiction. So it can create a more richful or complex discussion to try to see where things are. I think the core that can help us move forward is things that were already mentioned, is that at minimum, we need to have data standard and that metadata so that when we get to sharing and using of the information, we can have something that makes sense and that we can actually make use of the data. The specific ownership and who owns what and whatever, it's something that kind of is a broader discussion, but the important aspect is that if there is a need to get data insight about this information, is to figure out a way to make use of this information, regardless of where technically the information is, because as the technology evolved, the specific aspect of it is less at the core of the discussion, and it's more the use, and the use then goes into everything that we've discussed in this session about the trust and showcasing what can be done, and then making sure that there's full transparencies.
Thank you, Susie. Thank you. And let me go quickly also to Arturo. Arturo, it seems like there is a lot of thoughts going around of how do we keep this separation between data for statistics and data for more operational purposes, especially now with the heightened use of different sources during COVID. So what is your take on how do we safeguard this special status of the statistical system, or should we keep that?
Thank you. So I think that a little bit has already been mentioned. I think that the role of the statistical system in terms of providing quality data is key. That builds or that helps with the problem of trust that I mentioned also is we're starting to see creeping in a lot of our countries. I want to echo what Gabriel mentioned in terms of demand-driven approach that will make it more relevant. And let me, I know we have just a minute, but let me say this. Many of these legal frameworks that we're having built separately from each other require different public entities to have sort of officials within their organization. So many data protection legislation requires a data officer in every public entity. They already have someone that is the interface of statistics, right? Many of them also require someone that is in charge of opening up the data. They also have someone who is in charge of the interoperability role that they have, either within the same department or on different structures. So why don't we, I mean, and they're the first ones when you talk to them to tell you that this doesn't make sense. You know, it's just, they're torn in different directions, and that's when it's the same person and they can see it. Within the institution also happens. So starting to just, you know, sit on a table and having those conversations will be really useful. There is a need for someone to say, what are the standards? what is the metadata, what is the, how do you describe this, you know, very basic stuff. And that could and should be probably statistic office. So I would say that there's just a need to start, you know, building bridges and actually crossing them. Thank you.
Thank you, Arturo. That's a great message, I think, to close now the questions, the Q&A. Thank you for all the speakers for their engagement and for their advice. Well, we are running out of time, so I will just say that it seems that there is a general, I think, understanding that statistics legislation and these frameworks, regulatory frameworks that come with it, are needed, and they have been quite strong foundations for the COVID era, for example, but they are not sufficient. So as our panelists have mentioned, this will not bring changes automatically. There is a lot of work, as we have heard, behind on coordination, and then actually making the statistics law, implementing it, and rolling it out efficiently. So I would just like to thank again all the speakers, thank them for their time and for all the information that they have provided. And we hope that this session has been interesting and has provided a bit of an overview on the changing data legislation system. On behalf of Paris 21 and the Inter-American Development Bank, I would like to just thank all the audience for joining us and wishing you the best for the remaining sessions of this virtual forum. Thank you very much.
Thank you.
Thank you.
Thank you very much.